Hey there.
Any boarding this morning?
I haven't, but we can let people in. Our Zoom is odd. It has a waiting room. That's you. All right.
Maybe they updated it that way.
I don't know.
Morning, Judge.
Hey, Miss Simpson, how are you?
I'm good. I heard you went out of town.
I did. Morning.
Everything good?
It did. It was cold, but it was good.
Awesome.
Yep.
Good morning.
Yeah, we are.
If he's working.
If he's working today, hopefully someone is.
You know, I think he was helping another courtroom.
Okay. Morning, everyone.
Good morning, Judge. How are you?
We're waiting on a deputy.
Okay. I would like to speak to him for maybe about 5 minutes, if that's possible.
Sure. Or at least to touch base. Depends on how long we're waiting for deputies. If we wait too long, yes, of course, you can start with him, but it may be more like 1 minute rather than 5.
I got you.
We've got some back-to-back stuff today.
Okay. I did go and see him and drop those things off on the day I told you that.
Okay, I appreciate the work you've been doing to try to keep things moving forward.
Yeah.
You got a complicated situation you inherited.
So Judge, when there is a contempt order generally, and it just says that petitioner is required to pay $4,500 and then to purge, 20 days in jail, $4,500 to purge, and then $1,000 fine. Who do you pay that to if the order isn't specific?
I think the clerk's office, but the clerk's office may turn you around, saying, it doesn't say to whom it's supposed to go. That sounds like a family division thing where it might be that it's child support or alimony that's delayed. And then you'd think, well, maybe it would be payable to the attorney on the other side so that she could disperse it to her client. I don't move in that circle much. But the default would be to get it to the clerk because then it goes into the registry. It's in a safe place. And you'd provide proof to the judge. Here's the receipt. Clerk signed for it. There's $4,500, there's $5,500 sitting in there. Because the fine, of course, that's not going to go to the parent or whatever it is.
It's just a weird order because it talks about 20 days to serve for the contempt violation. In a separate sentence, it says $1,000 fine. Then in a separate sentence, of $4,500 to purge.
To purge.
But the purge isn't necessarily, it doesn't.
It's not
reference the 20 days.
Right. Does that mean the fine would go away? What? Yeah.
I'm assuming it means the 20 days would go away.
I think so. That's typically what you're purging. That's such a sensitive area when you're locking someone up. The goal, I think, is to make the order as clear as can be. What does this do for you if you pay this? And also equally important, to whom do you pay it? Did you lock the door behind you?
No, there's nothing with the trash there.
It is? Okay.
Maybe
Is there a Zoom link that I can share with his family?
Yes.
She send it out?
I'll forward it to you if you don't have
That'd
it.
be great.
Sure. Thank you. I think it's set up for the plea that's happening right after this, but it's up now. I powered it up. So let me send it to you.
was down in the northern district of Florida trying drug and firearms case. And, I tried it back in August. And,
Where is that Jacksonville, Tallahassee?
I think Jacksonville is included in the northern district.
Okay.
This was in Tallahassee. And so they acquitted client of all the firearm charges. They hung on drug charge, which was marijuana. So it's like, why are we, I understood why they brought it.
Yeah.
Because of the gun.
Right, but the guns went away.
Guns went away, and so I'm begging them. And they have a policy in their office that they don't negotiate. You either plead open to the indictment,
Huh.
and that's it.
Okay.
And so the guns went away, and so I said, hey, can we give them some probation maybe? You know what I mean? Everybody, it's marijuana.
All right. Good morning. How are you? Great to see you. We figured you were tied up in roll call or something.
I didn't get a key.
Or whatever.
I don't know who's the burglar, but I'm gonna be on it.
Okay, Mr. Hairston is the guy we really need right now. I think this afternoon is a Zoom from the jail, and we've got a plea, but I think the plea is guy's on bond. I think you should only have one.
I think that's 2 or 3.
Okay, well, Hairston is the magic person right now. Great, thank you.
We had to go retry it, because they wouldn't offer anything. It would have filed before.
So you retried a marijuana charge.
Retried marijuana.
And?
So the ones, you know, it always gets back to the government that time around.
Right,
All of the information was from, or all the evidence was really from DMS, it was the Instagram. And so they acquitted them on the marijuana.
just because they thought it was what,
You know, they wouldn't let us talk to the jury. There's a provision down there that they, you know,
Wow.
don't talk to the jury.
okay.
And so I was just like, well, how am I ever supposed to learn?
What my magic was.
Yeah. I couldn't believe it. In fact, it was so funny. I was researching when the judge said that they had a verdict. I was researching the detention statute to try to figure out how to keep the client out on bond pending sentencing. Mom has FedExed me. I'm supposed to receive today his clothes.
Okay.
We'll bring it back over to the court sometime today too, so.
Great.
So I'm not telling you something that's gonna start doing. Look at this text. Chris, reserved for this.
Morning.
What we're doing, man? Do you know Corral McCrimmons? I don't. How you doing? Corral McCrimmons, nice to meet you.
Just me.
How you doing, man?
Let's see here for calendars this week.
Oh, okay.
Hey, Deputy Gordon, can Mr. Banks meet with Mr. Hairston for about 2 minutes? Mr. Banks, unfortunately, I got to keep it to about two.
Yeah, Teams on.
Yes.
Okay.
Ms. Rios, we're running a little behind because it took a bit to get the defendant up here. So I need to work through Mr. Hairston's situation before we can turn to Mr. Scott.
No worries, Judge.
Is he going to be coming in here or will he appear virtually?
Mr. Scott is on Zoom.
Is he the
I think it's the Motorola.
Motorola?
Is that you, Mr. Scott?
Thank you, Judge.
Well, we'll figure it out. We're going to turn to Mr. Hairston now. All right. Good morning, Ms. Rivers. Are you able to get on the record?
Good morning, Judge. Welcome back.
Thank you. Great to be back.
Wait, I'm ready.
Okay. Well, let's get on the record. This is 23 SC 188908, State versus Hairston. Mr. Hairston is here. Good morning, sir. He is here with his lawyer, Mr. Banks, and Mr. Banks' colleague, and then we have Ms. Willingham for the state. Mr. Hairston, we need to talk a little bit about representation. Mr. Banks has kept me posted as much as he can without revealing any confidential communications between you and Mr. Banks about the ups and downs in your relationship with him and your desire to maybe have a different representation situation that has also been up and down. I need to help you understand where we are, the crossroads we're at. We are starting your trial on Monday. There has been a long, long wait for you, for the victim's family, and everyone else. And through no fault of your own, you've cycled through a couple lawyers. This is not a situation. I want to be very clear. I do not view this as a situation, because we get it sometimes, where there's a defendant who, for whatever reason, wants to avoid trial. And so he works with a lawyer for a while, then he fires that lawyer for the only reason being given, like, well, we're not getting along. And that's not your case. You had a lawyer at first who had to take a leave of absence because she was ill, but as far as I could tell, you got along just fine. Then Mr. Johnson, and out of a bad series of coincidences, he became very ill. But everything I had heard was that the two of you got along all right. A couple lawyers pitched in on a temporary basis to keep your case moving forward, but made clear they weren't going to become your permanent lawyer. And then through an effort of your family and these other lawyers, Mr. Banks was brought on board, which was a pleasant surprise to me. He is a private attorney who doesn't handle lots of cases in state court because he's very busy handling very complicated federal cases. And so he's in Florida and elsewhere in Georgia and around the country doing federal cases. But he also handles cases locally, and he stepped forward and filed an entry of appearance on your behalf. And since he's done that, he has been litigating on your behalf very effectively. We have paused the proceedings so that you could get an evaluation. He shared with me, again, protecting confidences with you, some of the steps he's been taking to be as prepared as possible for trial, faced with the evidence that's in this case. And the little bit I've heard from meetings with your lawyers is that there's a lot of evidence that favors the state's case. So it's a complicated case for the defense. That being said, I have no indication that Mr. Banks is anything other than ready to go forward on your behalf. So we need to work through today whether you want him and his associate to represent you starting Monday morning, or if you want to represent yourself. And then technically there's a third option. If you are able to bring a lawyer on board who wouldn't know much about your case, but says, that's all right, I can learn quickly, and is going to be here Monday morning to pick a jury. You can have any lawyer who files an entry of appearance. I don't want to preclude you if there's another lawyer you have in mind that you can afford and who tells you, I can be ready because I know what the case is about. I don't know that that lawyer exists, but that's not my decision, that's yours. Assuming that cannot happen, then I'm looking at the three people who are possible representatives of you for your trial. Mr. Banks's legal team, that's two. or you representing yourself. And you have that absolute right, and we can have a conversation about that if you want to represent yourself. But otherwise, Mr. Banks and all the work he's been doing is what is going to be representing you on Monday morning. And I thought it was important that we have a face-to-face conversation about that so you can share with me your concerns. And I did get a letter that you wrote where you indicated you feel Mr. Banks isn't prepared. I don't have that sense from my interactions with him, the motions he's filed, the things he's trying to keep out at trial, certain body cam footage and certain testimony. Those are all, to me, the hallmarks of a lawyer who has dived deep into the evidence and sees where there are things that there's a legal basis to say, let's keep this out because it's prejudicial to my client and there's a good faith argument to make that this should be excluded. And all this has been happening. So I just talked a whole lot, but I wanted to give you my view because you shared your view with me in that letter of how things have been moving forward with your case since Mr. Banks has been involved. We slowed down at his request, which was your request, for some of the work that was done in terms of mitigation and a defense. And we're done with that phase now, and it really is time to move forward. And that's what we're going to do on Monday, assuming it's not a plea. I don't ever want to take that off the table either, but that's a decision for you and your lawyer based on negotiations with the state. So tell me, without going into, I'm not asking you to share private conversations you've had with your lawyers. Tell me where you are right now in your thinking about how you want things to move forward on Monday.
Yes, Your Honor. If I may.
And can you bend the microphone down, and is the light green on there?
No.
Okay, if someone will put his finger in that little well, it should turn green. Great. Yes, sir.
How you doing, Your Honor? If I may state something for the record. So Tanya Miller was my first attorney. My family paid her $50,000. Like you said, she became ill. My family was never refunded or compensated any of that money as she handed my case over to Ted Johnson. Ted had a stroke and could no longer represent me as well. Attorney Banks came on to my case, and we've only met 5 times. I understand that you feel that he's prepared, and I'm not saying he's not prepared, but we haven't had much communication regarding my case. The first time that out of all 3 of my attorneys that I ever laid eyes on the evidence was this past Sunday. We haven't had communication as it relates to a defense, a strategy. I haven't been a part of the defense. There's been a lot of difficulties understanding the facts of the case. There's been a lot of difficulties understanding what has been done on my behalf or for me.
When you say, I don't want you to go into things you've exchanged with your lawyer, but when you say difficulties understanding the facts of the case, give me an example of, like, you're not sure what the evidence is, or you're not sure what the state is accusing you of?
I'm not sure of what our defense is, the strategy. I'm not sure of, I just saw evidence on Sunday.
Okay.
So understanding what it means, and as far as what our approach is, as far as all of that evidence, as well as there hasn't been any conversation about investigation that has been on my behalf, any things that have been looked into. I know that Tanya had some photographs. I don't believe those photographs have been given to Attorney Banks. There's just a lot of things that haven't really been sufficient. And as it relates to my defense, I'm in the blind. I don't know really
Well,
what's going
I'm,
on.
I'm gonna, push back a little bit on that I don't want you to tell me, well, Mr. Banks said this or that. But Mr. Banks and Ms. Willingham and I have had some fairly detailed conversations, where he has relayed, somewhat indirectly, because he doesn't want to disclose confidential exchanges between you and him, defense theories and work that he was doing and reasons why. Basically had to articulate it because he was asking for more time. And my pushback was, Mr. Hairston's been sitting in jail for hundreds and hundreds of days. Why do you need more time? And if the answer was because I'm busy, I'd say, but we all are. But that wasn't his answer. And I pushed him to be sufficiently detailed while protective of privileged information to let me know, that there were defense theories, not just that he had, but that you had, and that you had articulated to him. So I'm not disagreeing with you if you say you've met 5 times or 6 or whatever the number is. Clients who are in custody rarely think they've seen enough of their lawyer. It's difficult for the two of you to connect. It's not simple to do that at the jail. It's particularly difficult for Mr. Banks or any lawyer to share, for example, digital evidence. Here's some body cam. I have to sign a special order, which your lawyer asked for, and I signed, so he's taking care of all that. But defendants who are in custody rarely feel like they've had enough time. But that's not the test. Because then we would have a defendant able to say, I still haven't had enough, and we're going and going until the defendant says it's just right. It's a judicial determination of whether there's been adequate time and adequate interaction. And I'm telling you that based on things Mr. Banks has been able to share with me about his thoughts about when to move forward and how to move forward, and resources that he was trying to pull together on your behalf, that Mr. Banks and his team are more than adequately prepared, and that he has had enough time working with you to get a feel for your theory of the case, but more importantly, his, because he, if you end up having a lawyer representing you, he's the advocate and he's the one empowered to make those decisions of, you know what, we're not going to use, I'm making this up 100%. We're not going to use self-defense. That's not credible because the victim was shot 3 times in the back. And that's not self-defense. So I know you're saying it should be self-defense because the victim was 2 feet taller and had beaten me up 4 times earlier in the month. But I can't use that defense. So we're going to use something else, accident or alibi. And ultimately, that's the lawyer's decision and not the client's. But of course, there need to be communications about it. And I know you've had communications because Mr. Banks has said, because of the conversations I've had with Mr. Hairston, I need to do X and Y and Z. And that takes time and resources. And so, Judge, I'm asking for a continuance. And I've said, yes, you can do that. But I made plain to Mr. Banks that the last time he asked for one, not because of his schedule, but because of work he was doing on your case, that was the last time. And so let's set this case far enough out that when we reach it, you, Mr. Banks, will have had enough time to do the things you need to do, which is how we arrived to Monday. So I hear you that you would like to have had more time with your legal team and that you feel like there has been inadequate communication. But that leads me to say, you can choose to represent yourself if you feel like your team isn't going to do an adequate job, or you can let this team that I'm finding has demonstrated that they are prepared and that they understand the dimensions of your case, the strengths and the weaknesses and the problems that a defense has to overcome in this case.
Your Honor, may I?
You sure can.
That's the problem right there. The things that you and Attorney Banks may have discussed have never been discussed with me. And therefore, I believe the things that he said to you are not true. I don't really trust him in the fact of that's the things that you just stated are things that have never been communicated to me. And it's not my purpose in delaying trial. I want things to move on, the proceedings to continue. But how can I believe someone has my best interest at heart? How can someone defend me in this relation with not even discussing anything with me? he's, again, 5 times, the fifth time being Sunday. The last time I saw Attorney Banks was in November. And so, yes, we got the continuance that was granted on December 2nd, but I hadn't seen him until Sunday.
And if there wasn't a whole lot to report back because there hadn't been a whole lot that changed with your case, what would a meeting in December have been all about? We're only talking about a couple of months anyway. You know, you're making it sound like it's been a year, but you know, it's the holidays, it's a couple of months, and if there isn't something new to report, what's the purpose of a meeting?
Your Honor, there's been nothing that has ever been reported. And that's the issue that Attorney Banks and I have. There's why there's no trust there. There's more than just communication issues. Everything that he said to you isn't true. It's not factual at all. The things that him and I have discussed have been nothing. We
Okay.
haven't discussed anything as it relates to my case. So although things may have not changed from November to now or from any time before that, we still haven't discussed anything prior.
Okay, well, I'm hearing two different versions, and I'm going to credit the one I choose to credit. But again, you are the decision maker in terms of representation. And I need you to let me know how you want to move forward on Monday. We're getting close here today, so we'll get you dressed out. And if you want to represent yourself on Monday, you can do that. But there's a whole conversation we need to have about the wisdom and really the lack of wisdom of self-representation. But we aren't going to switch lawyers again. You have the able, capable, and prepared legal team seated on either side of you that's ready to go on Monday. And you can move forward with them or you can move forward solo. I just need you to let me know which of those, there's not a third option. Other than, like I said, you could bring someone else in. But option 3 is not, hey, you know what, let's get together again in 3 months so you feel a little better about the situation.
Your Honor, I do not want to represent myself.
Okay?
I don't understand how or why I would be forced to have Attorney Banks when our relationship is non-reconcilable.
So if Mr. Banks asks you questions about witness X, are you going to answer those questions or are you going to refuse to interact with him?
Your Honor, our relationship has been severed. There's no way for us to move forward.
Well, you are actually telling me then that you're going to represent yourself, because if you're not going to work with Mr. Banks, then you're going to work with yourself. You don't get to play the game, because this is what it's becoming of, you know what, here's another lawyer, I'm not going to work with this one, I need to get that lawyer that's just right, and then I'll move forward. Nope, Mr. Hairston, you have two choices. You're going to work with the lawyers who I find to be prepared and have your best interests in mind. And you don't get to say, I'm not going to talk with him. You can say, I'm not going to talk with him. I refuse to interact with my lawyer. That makes it a whole lot harder for your lawyer, or you can represent yourself. But if you want your advocate to benefit from your insights, then you may want to interact with him. But I don't control that dynamic. You do. I just know that you've got two lawyers flanking you right now who have your best interests in mind and are ready to move forward on Monday. You can make it easier for them by meaningfully interacting with them, or you can cross your arms and say, our relationship has been severed. You actually don't get to sever that relationship. I can, I'm not, unless you tell me you want to represent yourself. And then we have that conversation where I can conclude that you actually are knowingly and intelligently making the decision to represent yourself. Yeah. So I'm happy to let you talk with your lawyers for a little while longer while I turn to some other matters, but you are trying to create a third option that you don't have.
May I, Your Honor? I'm not trying to be difficult. I'm not trying to represent myself. I don't have the capacity to represent myself. I never chose to get rid of any of my attorneys. This hasn't been an issue of me trying to delay this case in any way. I chose the attorney that my family retained
Sound went out.
Ms. Rivers, can you hear us again?
Yes, I can.
Okay, what was the last thing you heard before the podium moved elsewhere?
The last thing he said that I received was, I chose the attorney that my family retained.
Got it. Okay, so Mr. Hairston was recapping what we've already covered, which is that it wasn't his choice to shift attorneys. I appreciate that. But I've known that coming into today's conversation. So we are where we are. And we're not going to delay for you to try to find another lawyer. One, I don't know how you're going to afford that other lawyer. But two, you've got lawyers who are ready to go.
Your Honor, if I may, I just want the opportunity for a fair trial. Because of the relationship that Attorney Banks and I have, where there's no trust, I know that I can't represent myself. I'm just asking for, because I am indigent, I'm just asking for a court-appointed attorney that can just,
Keep going.
where trust can be built and we can establish some sort of conversation and communication that will be to my benefit. That has just been something that hasn't occurred with Attorney Banks and myself.
Mr. Banks.
Judge, look, I don't have much to add. I do dispute that I've lied to this court, obviously. I take issue with that. I don't make representations to the court cavalier. It's a serious matter. He's facing serious charges. Having said that, I remain willing and open to work with Mr. Hairston in this serious matter. In fairness to Mr. Harrison, I will say he's been given a raw deal insofar as the representation. I stepped in to help two other colleagues out, and so I will continue to do that as best as I can under the circumstances. But I feel his pain in some respect. I really do. I have had the case less than a year. I know the court has been very clear with its direction to me concerning moving this case forward because it is, as I understand it, one of the older cases on this court's docket. And Mr. Douglas has been sitting in jail for an extremely long time. And of course, the victim's family has been waiting their day for this to be resolved as well. without getting into attorney-client privilege about what we have communicated and what we've not communicated, I will just simply say that, one, again, I feel his pain concerning the time he's been able to spend with me. But that's all I can say.
Okay. No, I appreciate that. And I believe I started the conversation by noting that this is not one of the cases where there's a defendant who keeps firing lawyers and it's plain from the conduct that it's just an effort to delay things. That's not your situation at all. You had to move on from the lawyer your family chose, not because you two didn't get along. I get that. Mr. Banks has been in this case for enough time. It was May 25th of last year that he came into the case to be prepared. I believe he is prepared, and I'm confident that he can zealously defend you. I also, because I've had a number of hearings about your case, know that your defense is going to be complicated. The evidence is not great for you. I don't know that the defense is going to be someone else did it. It's not a case I necessarily want to pick up and say, I've got a phenomenal defense for it. But that's not a sign that your lawyers aren't trying or that your lawyers aren't skilled. Sometimes the evidence is problematic for the defense, and sometimes it's not. But I want to turn to Ms. Willingham and see if the state has anything to add. And then I'm going to have you and your lawyers talk a little bit back there, and you can let me know with finality whether you want to represent yourself or if you want to move forward with the legal team that has been working on your behalf, even though you don't feel it and you claim that the relationship is irretrievably broken. We're coming up on 9 months now. And so I do believe they're prepared to do what they can on your behalf. Ms. Willingham, anything you want to add from the state side?
Judge, not much. The only thing I would speak to is, I know the defendant mentioned something about getting a court-appointed attorney. I would just argue that although I know Mr. Banks is technically a private attorney, I think that, quite frankly, Ms. Miller also even acknowledged that I am not in private work, so I don't know what they charge, but she acknowledged herself that realistically the amount of work that this case would have taken for any of them, those funds would have been exhausted well before I've actually left the office for 7 months and came back. And she said those funds would have been exhausted very early on. I believe almost right after our bond hearing, which was, I think, maybe a week after the plea and arraignment. So with that, again, I recognize that, Mr. Banks is a private attorney. The defendant has essentially had the work of a unpaid, or I'm not going to say unpaid, but a public defender, just by way of a private attorney who, quite frankly, I've had several conversations with Mr. Banks. So I think that he's more than ready to proceed forward on this case next week. So that would be all from the state.
Is there any evidence that you have come across very, very recently such that there would be a basis to say, hey, I would be ready, but the state just gave me the cell phone extraction from Mr. Hairston's cell phone?
Judge, no. There were a couple things that I sent over to Mr. Banks again, but it was more so because I just wanted to make sure that everything was streamlined. In fact, we even spoke at great length about making sure that we were looking at all of the right video footage and that everything was, he's had everything for quite some time and has inquired about a lot of that evidence, but there's nothing new that has been turned over that I think would make any difference at this point.
So maybe put differently, the state's file was complete even during the Ms. Miller or maybe the Mr. Johnson era. I know you went above and beyond to ensure that Mr. Banks basically got everything again because there was a lot of difficulty retrieving Mr. Johnson's files. I recall Mr. Richardson and Mr. Walker saying, we're doing our best, but Mr. Johnson really was focused, as he should be, on his health. But if we go back to May or June of last year, that's when you were pushing across to Mr. Banks and his team. Hey, I'm just giving you this again. Maybe you get it from Mr. Johnson, maybe you don't.
Yes, Judge.
Okay, understood. Anything else, Mr. Banks, you want to add? I'm not, I just wasn't sure. I couldn't tell if you had something you wanted to say in response to what Ms. Willingham said.
You know, anytime a client expresses, the deterioration of a relationship, it does give me pause, if I'm to be honest with the court. And I understand the court has to make a decision as to what his options are. While I've tried to keep the lines of communications open with Mr. Harrison, I am concerned about continuing, my efforts to speak with him because it will require his active participation.
Right. Okay. I appreciate that. Mr. Hairston, here's where we are, and I'm gonna sound sort of like a broken record, or at least that I'm repeating myself from the beginning. I find that, Mr. Banks, I don't mean to be incorporating your associate. When you go forward on Monday, assuming we go forward on Monday, we'll both, you, Mr. McCrimmon's, is that correct? That's right. Will you both be here?
We will.
Okay, so this legal team, not just one lawyer, but two working on your behalf, I find that they are prepared, that they have had more than enough time to process the state's evidence, and that they can more than adequately represent you and your interests at trial on Monday. You, Mr. Hairston, are going to decide how much easier you make it for them by meaningfully interacting with them. I can't force you to be a partner in the process, but we are going to go forward on Monday. And the one variable would be if you decide I want to shed them, that they actually are going to make it worse than if I do it myself. And I haven't heard you say that. I don't think that's what you're going to do. So I guess I'm encouraging you to reevaluate your position about interacting with these lawyers. You will make their job harder if you don't interact with them when they have questions or when you have thoughts and ideas that you want to share with them. But I don't find that you are facing a situation where you have lawyers who are unprepared, don't know what the case is about, or who haven't made good faith efforts to maintain a relationship with the client. And I'm not going to let you sabotage it so that we don't go forward on Monday. There have been months and months for us to have dealt with this, and it's an interesting coincidence that it comes up now. But I just want you to understand that you'll be back on Monday morning and we'll be going forward, and you're going to be making the adult decision of whether you collaborate with your lawyers or if you sit there sullen and choose not to assist them as they try to navigate the trial. Okay?
I don't have a choice.
I've told you your two choices, and you've told me you're not interested in representing yourself.
I didn't say I wasn't interested. I said I'm not capable.
Okay. Do you want to have the conversation about representing yourself, or do you want to save that till Monday because you're going to think about it more?
I'm not capable of representing myself.
All right, then we'll stay away from that one. And then that says to me, absent someone showing up on your behalf on Monday saying, nope, I'm here for Mr. Hairston, then you understand what we're doing on Monday. Okay? Thank you, Mr. Banks, Mr. McCrimmon.
We go to the back. Just
Yes. Oh, yeah, we've got that. That'd be great.
And Judge, unless I'm needed back, may I be excused?
Yes, ma'am. We have an afternoon calendar, but I don't think you'll know if you have something on it.
But I'll log on.
Okay, sounds good. Appreciate you being here. Ms. Smith and Ms. Rios, I have to go handle an adoption. It will not take long. I'm gonna go back and do that in chambers. It's online as well. And when I get back, we will handle Mr. Scott's case. Mr. Scott, are you good for another 10 minutes before we take care of your situation?
Yes, sir.
All right, appreciate your patience. I'm gonna just leave this up. I'm gonna mute the podium so it's quiet in the courtroom, but otherwise, I'll just come right back out, okay?
Okay, no problem. Yes, sir.
Thanks. Okay, everyone, let's let him in. Ms. Smith and Ms. Rios, you guys ready?
Yes, Your Honor.
Yes, Your Honor.
All right, let me get you. Ms. Smith, we'll add you. Good morning.
Good morning.
And Ms. Rios, and where's our Motorola? There it is. Add spotlight. There he is. All right. Mr. Scott, are you able to get to a place where you can stand? Are you heading to a place where you can sit or stand still?
Yes, yes, sir.
Great. Sorry to keep you waiting. Ms. Rivers, are you good to go?
Yes, I'm ready.
Fantastic. Then let's get started. This is 25 SC 004-557, State versus Tremaine Scott. Mr. Scott is appearing virtually, as is his lawyer, Ms. Rios, and Ms. Smith is appearing virtually, so we've got everyone on. Mr. Scott, before we can start the actual plea conversation, I need you to let me know that you are okay appearing virtually. You have a right to be here in open court, but you are somewhere else. Are you okay with that approach?
Yes, Your Honor.
You also have a right to have Ms. Rios right next to you, so you could speak with her confidentially if you needed to. But she is at her office and you are wherever you are. Are you okay proceeding with Ms. Rios appearing virtually also?
Yes, Your Honor.
If you need to speak with her privately, let me know and I can put the two of you into a breakout room so you can have a private conversation, all right?
Okay.
Okay. Then what's going to happen is in just a moment, Ms. Smith is going to put you under oath, ask you a bunch of questions about your case and your rights. You need to answer those truthfully and completely. You also need to let me know if you've got any questions of your own. Will you do that?
Yes, Your Honor.
Okay, let's get started.
Yes, Your Honor. Before starting, I just wanted to make the court aware that this will be a misdemeanor plea, and I can provide you with that code section of that, a reduced charge.
Okay, please do.
The reduced charge is reckless conduct, OCGA 16560.
Great, thank you.
Problem. Okay, Mr. Scott, may you raise your right hand? Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can lower your hand. Please state your true, correct, and legal name.
Tremaine Von Scott.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No,
And is there any medication that you would normally take that you haven't been given this morning?
no, ma'am.
How old are you and how far have you gone in school?
I graduated high school and I'm 44 years old.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have a right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment? One more time. Sorry, you went out.
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No, ma'am.
And are you satisfied with her services?
Yes, ma'am.
Counsel, are you satisfied your client has a full understanding of this proceeding?
Yes.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
Yes.
Mr. Scott, do you remember being arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants related to these charges?
No.
No, ma'am.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of time served, which is 31 days? Do you understand
Yes,
that
ma'am.
that's what okay. Are you aware that the court does not
Yes,
have to accept that recommendation and that the court can sentence you to the maximum on this charge, on this one charge that you have here?
yes, ma'am.
Okay. Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, even on a federal case?
Yes, ma'am.
Are you currently on probation?
No, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf and remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, I understand those.
Counsel, are you satisfied your client understands that these are the rights that they'll be waiving by entering guilty plea?
Yes.
Mr. Scott, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
Thank you. Thank you, sir. Thank you, Judge.
One more time, sorry.
No,
Okay. As to indictment number 25SC004557, how do you plead to the reduced count reckless conduct?
guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you do not have a right to appeal directly from your guilty plea? But if you believe that there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes, ma'am.
Do you understand that you have to request that discretionary appeal within 30 days from today?
Yes, ma'am.
Do you understand that you have only 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you, Mr. Scott. Your Honor, if this case were to proceed to trial, the state would show that on June 19th, 2025, officers were dispatched to 2450 Old National Parkway. That's the business Red Roof Inn in reference to an assault. When the officers got there, they spoke with the victim, who was identified as Ronald Nesbitt. Last name is spelled Nesbit. Mr. Nesbitt informed the officers that he got into a verbal dispute with the defendant, Mr. Scott, and Mr. Scott then attempted to assault him by trying to hit him with a crowbar. While talking with Mr. Nesbitt, he also told the officer that after he tried to attempt to hit him with a crowbar, he ran away from the car, dropping his phone, and Mr. Scott then picked up his phone and never gave it back. At this time, Mr. Scott was not at the scene, so he was not arrested for these charges at the time. It wasn't until later when the officers put out a bolo with a photo of his face, and they were able to identify him as Tremaine Scott. The officers went to Grady Hospital, where he was being held at the time, to talk to him about the incident, where he did say that he never made contact with the victim with the crowbar, but that there was a verbal dispute between the two about the damage made to his car after the defendant loaned it to the victim. And at that point, he did swing the crowbar, but did not make contact. At that time, the defendant was arrested for these charges that's before us today. And all of this occurred in Fulton County, Your Honor.
Okay. And you, Ms. Smith, have spoken with Mr. Ned, or have you been able to speak with him about this disposition?
No, Your Honor, we have done a victim locate and tried to call several numbers. We haven't been able to get in touch with him, which is why we decided to, one of the reasons dealing with this charge we have here today, the reduced charge.
Got it. Makes sense. Okay. I don't think we have anyone on from pretrial. Do you have any information, Ms. Smith, about Mr. Scott's criminal history?
Yes, give me 1 second. I just had it pulled up. Okay, what I have here is okay, there was one arrest for DUI in 2023, and that was transferred to Superior Court, but there's no disposition. Also an arrest for driving while license suspended. However, that was transferred to Superior Court with no disposition. And a third cycle for driving while license suspended and knowingly driving on a suspended license. However, that disposition says time expired restriction. And the fourth one is a theft by shoplifting charge that he was convicted of, misdemeanor from 2024.
Okay, got it. Thank you for that. You're a good stand-in for pretrial. Ms. Rios?
Yes, Your Honor. Mr. Scott is 44 years old. He lived in Georgia for the last 5 years. He has 4 children, ages 24, 15, 16, and 14. He currently is self-employed. He has his own publishing company called Mob Illustrated, I believe. He's a writer and self-publisher. I just ask that you accept the plea as negotiated.
Okay. Mr. Scott, tell me a little bit about the line of work you're in.
Yes, currently I publish books myself. I wrote them. You know, that's what I do. Like, I do the editing, put the book together, formatting, all that.
These are books that you have written or someone else has written and they need a publishing house and so they come to you?
It's both sides. I wrote my own and I also published some of my other friends.
Got it. What kind of books do you write?
They're really love stories, based on true story, urban novels.
Huh.
I have a series of like a spiritual book, a couple spiritual books.
And the name of your company is Mob, M-O-B Publishing?
Mob Illustrated.
Mob Illustrated. Got it. How long have you been doing that?
I've been doing that since I've been out in Georgia for the last 5 years.
Okay. And that earns enough to take care of the household?
Has to.
Okay. Well, good. Do you have any questions, Mr. Scott, about anything we discussed?
No, Your Honor.
Was this gentleman, Mr. Nesbitt, were you guys cars bumped, whatever it was he a stranger to you until that moment, or did you know him before?
I knew him beforehand.
How so?
He was like my brother. I used to let him use my car and stuff like that, and he stole my car from me and threatened me. You know how people fall out and have arguments.
Got it. Okay. When's the last time you saw him?
I haven't seen him.
Since this incident?
Yes.
Okay. All right. Well, Mr. Scott, I find there's a factual basis for your plea. You and Mr. Nesbitt got into it. Your plea is knowing and voluntary, meaning you've understood what we discussed and that no one's forcing you to enter this plea. Do you agree with both those?
Yes, Your Honor.
All right. Then I'll accept your plea. Ms. Rios, can someone in my office sign the indictment indicating the misdemeanor plea? Can they sign on your behalf?
Yes, Your Honor.
Ms. Smith?
Yes, Judge.
And Mr. Scott, is it okay if we sign your name to the misdemeanor plea?
Yes, Your Honor.
Okay. I'm going to sentence you to 30 days, 1 month. I think I have to say it as a month. I'm going to sentence you to 1 month to serve. In this case, you have served that, so you do not need to go back into custody. And that's it. So it's a misdemeanor conviction. You've served your time. I wish you the best with Mob Illustrated and your family. You have any questions about what's next?
No, Your Honor, and I thank you.
Okay, well, you should thank Ms. Rios. It sounds like she's strong-armed. Poor Ms. Smith. Ms. Rios, anything on behalf of the defense?
No, Your Honor. Thank you.
All right, Ms. Smith, anything else?
No, Your Honor.
So, Ms. Smith, and we can go off the record now. I'm just looking at the list for next week. I guess you still have the Charlie Daniels case if Mr. Majeski is available?
Yes, Attorney Majeski and I have talked and we've reached a resolution for that case. We're just trying to be put on the closest plea calendar so we can take that plea.
Excellent. Mr. Scott, you're free to go. You can stick on if you want. We're just talking about next week's calendar, but if you need to scoot, you're free to do that.
Okay, thank you, Your Honor.
You're
You guys have a good
welcome.
day.
All right, take care. So you're saying that Daniels is a plea. Did someone let Ms. Nelson know that, or should I tell her?
Mr. Majeski reached out to Ms. Nelson, I believe on yesterday, to try to see if we could fit in some kind of way.
Okay. All right. Well, then it looks like you're done for next week. And Ms. Rios, Denike was number 2 for Judge Emerson, but that other case went out, and Denike is now number 2 here. We met with Mr. Hairston this morning, and as of now, that case is still going forward. But I need to see you on Monday morning, please.
I will be there with Miss Wood too. She'll be
Okay.
right here with me because Miss Nix, I've been trying to reach her to resolve a case. Is someone going to be covering for her, or is that going to be you, Miss Smith?
Are you talking about this afternoon?
Yeah, who's covering
I can
for
reach
her?
out to her. And
She's in trial in front of Judge Emerson, so
Yeah.
she will not be available. But maybe Ms. Smith can find someone else in that unit, or Supervisor Sperry, who's listening in, can help out with that. But I know Ms. Nix is in the thick of trial with Judge Emerson.
Yes, maybe I can email Mr. Sperry, because it's I've been trying to resolve this case for a while, and I know we have a bond hearing. This is Sebastian Mateo Gambia. I think I'm saying his name. He's a Spanish interpreter case.
Okay.
So I'll send you an email, Mr. Sperry, in case you can help me.
A Peeping Tom case. Yeah, he's been in jail for over 200 days. Maybe we can sort that one out. Hopefully we'll have an interpreter available. That's going to be complicated over Zoom, but we'll work through it. Okay. I think that's it then. Ms. Rivers, and I guess Ms. Smith and Ms. Rios, I will see you all again this afternoon, the 1 o'clock calendar. I'll be ready. We'll fire it up a little before 1 o'clock, and we'll see what we can take care of.
Okay.
All right. See you soon.
All right. Thanks, everyone.
Bye-bye.